So peace be upon you. It gives me pleasure to welcome you today on the panel discussion on private military and security companies organized by the International Committee of the Red Cross in cooperation with our partner, the Montreux Document. I'm Basant Abdelmajid. I am a legal advisor in the Regional Office for International Humanitarian Law for the Middle East and North Africa at the International Committee of the Red Cross. I'm honored to be with you today to facilitate the discussion in the presence of distinguished and experienced experts in the field of international law, especially in the field of private military and security companies. Today, we have Dr. Muhammad Ghazi Al-Janabi, Assistant Professor of International Law at Islamic University in Iraq. He holds a PhD in International Law from University of Aberdeen in the United Kingdom and is also an honorary research fellow at the University of Aberdeen and an associate fellow at the Academy of Higher Education in the United Kingdom. Several publications in international law and a book on private military and security companies. With us, we have colleague Kilsiana Thani, a legal advisor in the advisory unit of international humanitarian law at the headquarters of the ICSC. So she worked with the ICSC for 10 years. She has a lot of publications and articles on international law and its application at the national level. She is responsible for the file of the PMSCs. We are also honored to have Mr. Jean-Michel Rousseau, the Deputy Head of the Business and Security Section at the Geneva Center for Security Governance. Before we start, I would like to clarify some technical issues. First, I will now show you how to configure the language. And so as you can see, the discussion will be conducted in Arabic and English, and simultaneous interpretation will be provided. This is the first event organized by two languages using the Kodo platform. You can choose the language from the left corner on the screen as marked here in red, and you can choose the Arabic language here, and you can also use the Arabic channel. So if you don't want to listen to the interpretation, you can just choose the floor. So the duration of the discussion is 1 hour. Half an hour is for the speakers and another half an hour for the questions you pose. All microphones are on silent, and in a case of any technical problems, please write the problem in the message box on the right of the screen marked in blue. So for the technical problems, please write it in the operators tab, either in Arabic or in English, and one of the technicians or the organizers will assist you. Please ask your questions or any remarks in the same message box, but in the section on messages and questions, either in English or Arabic. If you want to ask a question to a particular expert, please write the name of the expert directly to direct the question to him. Also, you can download the files on the tab Documents on the right corner of the screen, marked in green. The panel discussion will be recorded in both Arabic and English, and we will upload them on the IHL Nomads group on Facebook and on the Montreux Document Forum and ICSC page on YouTube, and also on the events page on the ICSC website. Now, we will start with our topic on the PMSCs. And as you know, with the increase of the presence of these companies, its use also increases in different ways around the world for many reasons. This is also noticeable in contemporary armed conflicts, including in the Arab region. As you can remember, the use of Blackwater's company that was used back in Iraq back in 2003, and other companies. report says that the use of these companies increase the humanitarian consequences related to the protection of the victims of armed conflicts and the possible violations of IHL. Among the international efforts exerted to respond to these concerns, the ICLC and the Swiss Confederation played an important role in highlighting the importance of having an oversight standards and regulations stipulated in international law and the national laws regarding the regulation of the operations of the PMSCs. This is also based on the provisions of on the international law binding to the states by virtue of the international treaties and the customary international law, as well as the good practices of many states, consultations and discussions with the experts and the countries affected by this phenomena, and which finally resulted in the issuance of the Montreux Document in 2008. So it's very important for the Arabic speaking audience to understand the nature of the PMSCs. At the beginning, we have Dr. Muhammad Ghazi, who will talk about the classification of these companies. And in a nutshell, briefly, he will explain the difference between the employees of these companies and the mercenaries. We can see a clear confusion in the use of these terminologies in the news, in the media, and in different narratives that even lead to many legal repercussions. We have also Kelsiana Thines, who will explain the legal framework in which these companies operate with regards to the IHL. Finally, John Michel Rousseau provides an overview of the Montreux documents and the tools and the services it provides, highlighting the international efforts and the good practices related to private and military companies. At the very end, we will give space for you to ask questions and answer. Now, I leave the floor to Dr. Muhammad Ghazi. Here you go. Thank you so much, Basan. Peace be upon you. Thank you so much for hosting me today. And thanks for the ICSC, the Montreux Document Forum, for focusing on this important issue, the private military and security companies. Now I will share with you the PowerPoint that I'll be using so that you can follow up clearly with me. So first of all, the use of the private military and security companies raises a lot of questions and legal problems related to the legal classification of its employees and on the applicable legal provisions and the state responsibilities and the application of IHL, IHRL, and the criminal liability of the employees. A lot of questions raised by the use of these companies. However, here I will focus on one part related to the classification, the legal classification of these employees. Are they employees? Are they combatants? Are they civilians? So, but before starting this, I will give you some remarks here. First of all, when I talk about these companies, there are a number of terminologies used to describe these companies. They are sometimes called private contractors, mercenaries, sometimes security companies, sometimes military companies, but actually the classification or the naming, labeling given to this companies is the private military and security companies, PMSCs. So today, we will focus on the labeling of these companies. And when I say PMSCs, I mean the companies that provide security services, and we will understand the classification of the security services that and also military services. And in particular today, we will be talking about the services provided at the time of armed conflict. Sometimes we find these companies everywhere, and about we had before we've talked about the use of the private military and security companies related to the refugees, related to the protection of the ships and so on. But today I will be talking about the companies, the military and security companies. Through these lectures I will be using the term in order to refer the companies that provide military and security services during armed conflicts. So the question here is, how can we specify the legal classification of these companies? First of all, I will be talking about how to classify this. I want to have an applicable classification for the employees of these companies. IHL is not dealing with the legal persons here. We have the civilian, we have the military personnel, but we don't have a legal person for this classification. So the classification today is related to the employees of these companies. How would I classify them? So in order to be clear and precise, I can't promise you with a final classification, one decisive classification for this, because we don't have just one comprehensive general classification that can be applied in any cases that we need to discuss every case separately, every individual case relating to the classification of the employees of these companies. So the methodology that I'm following in order to classify or to make or to have like an applicable classification in this regard relating to the entity that hires these companies. If it is hired by states, for example, so we have certain classifications related to either employees, civilians, or mercenaries. So and we can also be hired by like international organizations, humanitarian organizations, or can be used by the UN peacekeeping forces, and it can also be used in non-international armed conflict. So I won't have the time to cover all these aspects and all these assumptions, but however, generally I will try to focus on the hiring of these companies via states and the use of the PMSCs in the UN peacekeeping forces, and how would we classify these companies if used in this framework, in these two frameworks. So also we need to understand what the nature of the services provided, either military or civilian services. Does it reach the threshold of armed conflict? Also, we need to understand the type of the armed conflict. It's either international or non-international, because this play an important role in the classification and the legal classification of the employees of the PMSCs. First of all, we have the mercenaries. So in books, in the media, we have the description of these companies and the employees of these companies as mercenaries. So it's not strange to classify them as mercenaries, because there is a very big similarity between those employees and the mercenaries, particularly related to the aim of the participation international in the armed conflicts. So we have three factors here. First of all, that the aim of the participation in hostilities and the material gain here. Most of the companies are foreign companies, and foreign companies taking part in armed conflicts. Second, the participation in armed conflicts. So these factors are very important. So from a legal perspective, it's not that easy to make that classification, particularly when it comes to IHL. So in order to understand the framework of the legal framework of these companies, we have the additional protocols, and we have the African Convention and other conventions. But most importantly, I'm concerned with Article 47 of the first additional protocol. It added six important criteria for classifying those employees as like mercenaries. So there are a number of criteria that can really be applied to this. First of all, we have the material compensation or the financial compensation, which, because the participation in the hostilities is just aiming mainly at the financial compensation. So this is very important, a very important aspect in this classification. So this financial compensation needs to be even more than that compensation given to the armed forces of the state involved in the conflict. So these companies provide private services that are not present in the state armed forces. So the second term here, or the second condition here, is the non-membership in the state armed forces. And also there is no official mission, the nationality and the residence that the mercenaries, or if we're talking about the employees of the PMSCs, they shouldn't be killing in the state in which they hold its nationality. So this condition raises a number of questions here. This can be an applicable condition. For example, the use of PMSCs in Iraq. Most of these companies are American and British companies. So they are having the nationality of a party of a country that is party to the conflict. Sometimes this condition is not applicable, as we can see, but these companies are also used by hiring some other nationalities, hiring employees from East Asia and from different countries as well. So if the rest of the conditions are still applicable, so some of the employees have these conditions applied and others doesn't apply these conditions. But however, we have another conditions that cannot be, or it's difficult to apply them to these companies. First, to have the recruitment in particular for the fighting in an armed conflict. Mainly the PMSCs are sometimes used for the consultations, for example, but it's not mainly used for fighting. The second conditions that some companies may be used for a long-term contracts. For example, if we have a particular conflict, so this condition cannot be applied. Hiring the companies is just used for a particular conflict and some others are not. So the most important or the major problem that we have here is the active and direct participation in hostilities. A lot of discussions and a lot of problems are raised relating to this issue, like providing some services related to the consultations, and do they amount to a real participation of hostilities? So some companies rely on this condition in order to be excluded from the term mercenaries, or not to be labeled as mercenaries, because they don't actively or they don't directly participate in hostilities. So I have tried generally to describe the hostilities that can, through its nature or the purpose it used, can inflict real damage to the personnel of the armed forces of the belligerent armed forces. So all of these conditions have to be applied in order to label the company or the company's employees as mercenaries. And the armed conflict has to be an international armed conflict as well, according to the international humanitarian law and the first additional protocol. So this means that the contribution of the PMSCs in non-international armed conflicts, they can never be labeled as mercenaries. So here it is difficult to apply the term mercenaries to the PMCs. It's not about the companies itself, but it's about the definition or the conditions or the criteria related to the conditions. So the any of the mercenary who cannot be or who cannot evade this definition, he needs to be like shot, him and his lawyers, because this it's very easy now to evade such definition. There are a lot of problems related to that definition, and particularly when it comes to the PMSCs. Now, they cannot be mercenaries. Okay, so can they be combatants? So the employees, if they can be combatants, we have two options. The first option is to have a de jure relationship between the armed groups and between the armed groups and the armed forces, according to Article 4 of the additional of the Geneva Convention. So we can this can also include the militias and the voluntary troops. This can be form part of the armed forces. So what does it mean to be part of the armed forces? It means that there is a legal text that allows for the PMSC to be part of the armed forces. So this legal text has to be provided. So this assumption, okay, or this case didn't happen only except for only one or two times for the a company, an outcome company from South Africa, and it took part in Sierra Leone. This is the only case that this happened, the de jure relationship. So this is the first relationship to be part of the armed conflicts. Also, we have a de facto relationship. According to Article 4, paragraph A2, that it's an army group belonging to one of the parties or to the conflict parties, and we have two categories included here. So we have one category depending that this group, that this armed group is under the control of one of the parties or one of the parties to the conflicts. And the other condition or the other category of to having is to have the armed group under a clear particular command in the armed conflict. So this is related to the armed group itself. So also it is very difficult as well to apply this kind of relationships like the de jure relationship and the de facto relationship, because most of the PMSs provide services in a kind of in a free context, that if part of the any party to the conflicts and they have a particular control, this can be, and the company can be part of this of these armed groups, okay, according to the Okay, so we have also another possibility, and as you know, in the IHL, they are dealing in a sort of like coins. If, for example, if you it's like a coin. It's only one part. You can be either a civilian or a combatant, and this is according to the international humanitarian law. So the semi-militant, the semi-civilians, this is not there anymore. So if you are a civilian, so this is another description for the employees of the PMSCs. So the parties to the conflict, according to IHL, according to Article 58 of the first additional protocol, has the parties to the conflicts have to separate the civilians away from the military objectives. So in the framework of, and this is in the framework of armed conflict. So these civilians, they can be civilians accompanying the armed forces, and that's according to Article 4, paragraph A4 of the Third Geneva Convention. And this allows the presence of civilians with the armed conflicts, with the armed forces. And here they can have the status of the prisoner of war. So they can be classified, the employees of the PMSCs can be classified as civilians accompanying the armed forces, and this is the definition of the Ministry of Defense in the USA. And this option also needs a number of conditions. First, they need to have an authorization to accompany the armed forces, and this includes the war reporters and others. Also, this this list is not exhaustive. However, we have also the employees of the PMSCs, they should be accompanying the armed forces, which means that we cannot, if there is no armed forces, this condition cannot be applied. And thus the companies will be accompanying those armed forces. Also, this can be only applied in international armed conflicts. So it cannot be applied to non-international armed conflicts. And thus, when the PMSCs provide services to non-international armed conflicts or to non-state groups, this cannot be applied to them. Also, the provided services should not amount to the threshold of the effective or direct participation in hostilities. So this condition is very important, and I've talked about this also when I talked about the mercenaries. And it raises a number of problematic aspects when it comes to the definition or to the labeling related to the civilians accompanying the armed forces. Whenever these conditions apply, so now they are civilians and civilians participating in hostilities. So a person is normally a civilian, and then he can be a combatant according to specific conditions as well. So if they are civilians, there should, so if they are civilians, they cannot be target to the hostilities. Also, I believe that the employees of the PMSCs can be labeled as civilians according to the conditions that we have talked about. And if they took part in or they directly participated in hostilities, they lose their protection, and they cannot be to have the status of prisoner of war as well, and they can be held accountable for participating directly participating in hostilities, and thus they lose their protection during the period in which they contribute to the hostilities. Only during the period of their participation, and once their actual and participation or their actual contribution to the hostilities, now they are back as civilians. So now the PMSCs are commonly used in the UN peacekeeping forces. We know there are a number of problems and issues related to this regard. So I'll try to be brief here. First, according to IHL, the UN peacekeeping companies, according to IHL, they are civilians and they are protected as civilians. So they cannot use force unless for self-defense. So they are protected under IHL, and any attack against these forces is a war crime. So according to the rules of peacekeeping in the Convention on the Safety of the UN Unassociated Personnel, and also the UN Secretary General Bulletin on the Observance by the UN Forces of IHL, we have two important issues. First, that the peace enforcement forces are at any circumstances combatants, and also the peacekeeping forces, mainly they are civilians, but if they take part in directly in hostilities, they become combatants. As we said, according to IHL, if the civilian is a civilian directly participate in IHL, so the protection is his protection is dropped, and he becomes a combatant, and he cannot be labeled as a prisoner of war. According So any of the peacekeeping forces taking part in in hostilities, he now moves from being a civilian to being a combatant, and this is so the use of force by these forces is legitimate but limited to the self-defense. However, sometimes this changes. So we have like the third generation that these forces can use force in order to defend their mandates. They can use force in order to separate the belligerent parties, to use force to provide humanitarian assistance, to protect the civilians, and other uh, issues. That's why we don't have that narrow concept of self-defense, but also they can use the force to defend their mandates. So sometimes the peacekeeping forces use force in this context. So I won't have time in order to give more description about the employees of the PMSCs. They can be used by peacekeeping forces, so that the company can hire the company. The UN can hire the company directly, or the company can be hired by the state and then seconded uh, to the forces. Okay, so in the statement by UN Secretary General Kofi Annan related to the conflict in Rwanda, he wanted to propose the use of the PMSCs to protect civilians and to stop the genocide. But at that time, he said that the world was not ready for the privatization of peace, which means that if we use the PMSCs for peacekeeping, it means that troops will be civilians as long as they don't participate in directly in hostilities. So they will be civilians. However, they will be combatants if they directly participate in hostilities. So sometimes this raises a lot of problems and issues when it comes to the use of the peacekeeping companies seconded by some states. So the companies can be seconded. They become part of the armed force, and they cannot be seconded to the peacekeeping companies, the peacekeeping forces later on. So this raised a number of issues related to the fighting in the armed conflicts and the direct participation in hostilities, and so on. So, generally speaking, I'm sorry for taking too long. This is a very rich issue, a lot of complexities. And if you have any question during this, I'm so ready to hand you over. And thank you so much. I hope I have clarified everything. Thank you so much.
أعتذر على ضيق الوقت، ولكنك أجبت على العديد من الأسئلة، وأيضاً أعتقد أثرت العديد من التساؤلات الأخرى. فمن المهم جداً ما قدمته من تعريفات وتصنيفات فيما يتعلق بالشركات العسكرية والأمنية، أياً كانت من مقاتلين ومدنيين و
Now you have also clarified the difference between the mercenaries and the combatants. The mercenaries is used also is used in international armed conflicts. However, most of the conflicts that we have now are like non-international armed conflicts. Now we move to Kelsiana. Now you have the floor.
Much. I'm very glad to be with you all as part of this panel as a first for ICRC Cairo. And I'd just like to note that today is the 71st anniversary of the adoption of the 4 Geneva Conventions, the key treaties of IHL, which I will be touching upon during my presentation. So for many years, private military and security companies, which I'll refer to as PMSCs, have provided various services to states and other actors, as Dr. Khazi has already outlined, in armed conflicts. While PMSCs no longer dominate the headlines as they did 10 years ago, we do still continue to have reports about recent and indeed future use of private contractors in armed conflicts. The use of PMSCs is not necessarily a problem in itself. However, from a humanitarian point of view, the use of PMSCs in armed conflict can raise important concerns. For example, if these companies operate without clear rules on the use of force, if they lack adequate training on IHL and other applicable law, and if the states involved do not ensure effective accountability for possible violations by such companies of either international humanitarian law or domestic law. What's important to recall, however, is that while these humanitarian concerns exist, there's no gap in the law applicable to PMSCs. In many cases, there's just simply quite often a lack of enforcement of the law. IHL does not define who qualifies as PMSC staff. We might give a definition such as personnel of PMSCs are those employed by, through direct hire or under contract with a PMSC, including its employees and its managers. As Dr. Khazi has outlined, the status of the personnel of PMSCs in an armed conflict is determined by IHL on a case-by-case basis, in particular according to the nature of the functions in which they're involved in and the circumstances. Unless they're incorporated in the armed forces of a state or have combat functions for an organized armed group belonging to a party to the conflict, then the staff of PMSCs are civilians. Therefore, they're entitled to all the protections for civilians under IHL. They may not be targeted, that is, they may not be attacked or shot, and they're protected unless and for such time as they take a direct part in hostilities. And as has already been outlined as well, they may also have prisoner of war status as civilians accompanying the armed forces if they're operating in and captured in an international armed conflict. However, if the staff of PMSCs carry out acts that amount to taking a direct part in hostilities, they may lose protection from attack during such participation. And if captured, they can be tried for crimes associated with participating in hostilities, depending on the domestic law of the authority that detains them, even if they have not committed any violations of IHL. But they can and must, of course, be prosecuted for any serious violations of IHL that they commit. Just to give you a couple of examples, guarding military bases against attacks from the opposing party, or gathering tactical military intelligence, or operating weapon systems in a combat operation could be examples of direct participation in hostilities, in which PMSC personnel may be involved. And in which case, that's of course when they lose protection from attack, and they might also be prosecuted if they commit serious violations of IHL, or indeed if this goes against the law of the country in which they're operating. If they're operating in situations of armed conflict, the staff of PMSCs must respect IHL and may be held criminally responsible, as I've said. And this is true whether they're hired by states, by international organizations, or by other private companies. Particularly if they're hired by states, states themselves have a responsibility to ensure that they, as states, and the private military and security companies respect IHL. In Common Article 1 of the 4 Geneva Conventions, states parties undertake to respect and to ensure respect for the present convention in all circumstances. And as the ICRC's 2016 commentaries to the Geneva Conventions outline, acts or omissions which amount to breaches of the conventions entail the international responsibility of a state, provided those acts or omissions are attributable to the state according to the rules on state responsibility. This concerns not only the conduct of state organs, but also that of other persons or groups acting on its behalf, such as volunteer and militia forces, and in certain circumstances, private military and security companies whose services are contracted by the state. This is actually nothing new in international law. This is pretty standard law on state responsibility. However, the ICRC commentary goes on that the novelty of the provision of ensuring respect for IHL lies in the addition of the duty to ensure respect in all circumstances. So states are required to take appropriate measures to prevent violations from happening in the first place. Therefore, states must start in peacetime, take all measures necessary to ensure respect for the conventions. And this presupposes that preparations have been made in advance. The obligation to respect and ensure respect for IHL, therefore, is at the duty of states to ensure that any PMSC that they hire or that they register in their territory or that operate in their territory are in compliance with IHL. So 3 broad sets of obligations can be identified arising from this. Namely, states may not contract private contractors for tasks that IHL explicitly assigns to states, such as detention operations. States have to ensure respect for IHL by PMSCs through effective training and dissemination of IHL. And states have to investigate and, if required or appropriate, prosecute, extradite, or surrender persons suspected of having committed international crimes and, in particular, war crimes. Different measures both before and during a deployment are essential to ensuring that the staff of PMSC respect IHL. These can include incorporating respect for IHL and other applicable law into contracts with PMSC staff, vetting procedures for the hiring of staff, so checking the background of staff, proper training in IHL for PMSC staff, standard operating procedures and rules of engagement that comply with IHL, including and specifically on rules on the use of force, and internal disciplinary proceedings. IHL is not, however, the sole body of international law that applies in armed conflict. International human rights law, the law of state responsibility, and international criminal law all apply in both war and peacetime. And they also require implementation and effective measures to prevent, investigate, and provide effective remedies for the relevant misconduct of PMSCs and their personnel. States also have an obligation to investigate and to prosecute, extradite, or surrender persons suspected of having committed crimes under international law, such as torture, independently of whether such crimes are grave breaches of the Geneva Conventions or other war crimes. In regards to PMSCs, as with many issues around behavior and practice in armed conflict, once again, it's not that there is a lack of law, but the law is not necessarily applied effectively. So proper implementation of the law is what is needed to ensure that states and PMSCs and their staff uphold the law in armed conflict. Thank you, and I look forward to the questions.
Thank you very much, Kalsiana, for outlining the legal framework in which private military and security companies operate, and for highlighting the state responsibilities with this regard, specifically concerning IHL. It is indeed a very complex matter with a lot of case-by-case scenarios, like Dr. Ghazi also highlighted. But as you pointed out, contrary to what people may think, there is in fact no gap in the law applicable to PMCSs. The law and relevant provisions are there in different branches of international law, be it IHL, international human rights, or international criminal law. However, this perceived gap can be attributed to a lack of enforcement of the law. Thank you again, Kalsiana. Now I give the floor to Jean-Michel.
Okay, can you hear me? Sorry about that. Thank you very much, Basant, for the introduction, and on behalf of the Montreux Document Forum Secretariat, I'd also like to thank, as usual, the ICRC for co-hosting and co-organizing such an event as that one today with us. As was already said at the beginning, the Secretariat is hosted within the Business and Security Division at DCAF. Here in Geneva. The division looks at the role of private actors within the security sector as is the case of PMSCs. Just to flag that, as DCAF, we do a variety of aspects. We also have a number of geographical divisions, one of them also working on the MENA region, which has been working in the MENA region since 2005. And our focus in general is on improved service delivery, as well as accountability and legitimacy of security providers. Looking, quick introduction with regards to the background of the Montreux document, and I won't maybe go into all the aspects because it's already been touched upon by the other speakers. We've seen over the years a series of allegations of misconduct by PSCs, which includes war crimes as well as crimes against humanity, and that was the case before the Montreux document was created, and has been also the case since the document was decided upon, and I think that's also the reason why we continue to raise awareness, disseminate information on the Montreux document, try to get more states to support it, and also support states in implementing the norms and good practices that the document contains. I would just focus on two elements before turning to the document, then the content of the document. I think one general comment was that there was and there continues to be significant gaps in the regulation of PMSCs at the national level, and that includes monitoring of the activities, vetting and training of personnel, and the way force is used by PMSCs. And I think Keliciana made the point before. The frameworks are there. At least at the international level, there's international norms and good practices. But then when it comes to implementing them at the national level, and then also creating the mechanisms, the capacities for PMSCs to be adequately regulated, that's where there was gaps, and where we still see gaps, and which highlight the pertinence of a document such as the Montreux document. And additionally, another challenge is that even if in cases where PMSCs are well regulated at the national level, as if operations at the national level, when it comes to them operating in armed conflicts in other countries, a lot of times we have situations where they're not covered by the legislation and regulation of their respective territorial state, so to speak, so the state where they are operating, because a lot of times when they are operating in armed conflict, well, those are obviously contexts where the state is weak because there is now a conflict going on. We also have, then the PMSC is not covered by the legislations of regional home states, precisely because their legislations do not look at aspects of extraterritoriality. And then with regard to the third categories of states, we don't have, the contracting states, so the state that contract the services of the PMSCs, do not have sufficient rules on procurement and contracting in their own legislation. So, and I'm really making this point because we might have a case where at the companies operating within a given national context might be very regulated, but then there might still be, even then there might still be situations where the company based there but operating somewhere else, or a company contracted but operating operation somewhere else, would not be adequately regulated. The Montreux document, it was born from an initiative of Switzerland and the ICRC. The Montreux document it's born out of an initiative of Switzerland and the ICRC to reaffirm the existing obligations of states under international law when it comes to PMSCs. So it doesn't create, it's not a new legal text. It doesn't create new legal obligations, but it simply stresses that PMSCs do not operate in a legal vacuum. And I think that's a point that has been stressed by the moderator and my co-panelists before. There is already, this is a domain that is already covered by international law. So companies do not operate in a legal vacuum. And I think just to mention here, I think Kelly-Sian also said it before, the Montreux document does not make any judgment, does not express any statement on the legality or not of PMSCs. I think that that would be another discussion to be had, but it simply tries to look at what is already in place with regards to PMSCs in international law. The document has two parts. One which recalls the pertinent legal obligations of states regarding PMSCs, and those are the obligations based on the Geneva Conventions, meaning that if states have ratified the Geneva Conventions, they basically, they already have obligations with regards to PMSCs. And the second part is a description of good practices which aim to provide guidance and assistance to state in regulating PMSCs. And so this is like elements that are based on on good practices globally that would help states in making sure that the regulation of PMSCs is done in an adequate way. The Montreux document was developed with the view that certain well-established rules of international law applies to states in their relation with PMSCs and their operation during armed conflict. Just to highlight that the document also says that the obligations might be instructive for post-conflict situation and for other comparable situations. So, this is clearly a document based on IHL and IHL obligations, but that if states think so, if estimate it to be so, it can also be instructive for other contexts. And as Kelly-Sian already said, most of the good practices would actually ideally be put in place during peacetime. So this is a document that is not just relevant for states. One could say, this is a document that's relevant only for states that are in a situation of armed conflict right now, but that's actually not the case. It's a document that is relevant for every state, because from a prevention perspective, in order to prepare any future regulatory challenges. The document looks at three types of states. I already touched upon them briefly in the introduction. The contracting states, so the countries that hire PMSCs, the territorial states, the countries where the PMSCs operate, and the home states, so the countries where the PMSCs are headquarters. And that, I think, comes from two reflections. One simply being that there are a variety of states that interact with PMSCs on different levels, be it regulatory or contractual, but also that because states, whereas for example, the territorial state might not have the regulatory capacities because it's a state in the middle of an armed conflict. Other states that have a relationship with the PMSCs and that are not in a situation of armed conflict could still also play an important part in regulation. So that the state that hires the PMSCs and the states where the PMSC hailed from. The document is currently supported by 56 states and 3 international organizations. I've put the 4 countries in the MENA region that so far are supporting it: Iraq, Jordan, Kuwait, and Qatar. And the Montreux Document Forum is co-chaired by Switzerland and ICSC. I think I already mentioned that before. Just to give you a brief overview about the Montreux Document Forum, the forum it brings together all the actors that support the Montreux document, and the idea is to improve the regulation to be a gathering point for improving the regulation of the PMSC industry. And I say there's about 3 points here to mention. First is to have a platform for discussions on PMSCs and regulatory challenges, both in the plenary, in thematic working groups, and also in regional meetings. And the forum is more and more going for the format of regional meetings, because this is really where we can have the best interaction with practitioners in PMSC regulation, so people really involved in day-to-day regulation of PMSCs. The forum also provides support to governments, and that basically our advisory service, mostly by the Secretariat, to governments that are a member of the Montreux document but want to update and want to update their regulation based on the norms and good practices contained in the Montreux document. So the state has decided to support the document and then wants to implement the norms and good practices. And there, from the Secretariat sides, we can provide support, legal advisory for this to happen. And then just to flag that, obviously the participation in the Montreux document is also an important political message in the sense that the state signals that it deems the regulation of PMSC an important topic within the framework of international law. Just to follow up on the support to governments, I just wanted to put this as a last slide, and I've put it in Arabic because I think most of places so to not complicate the translation. We as a Secretariat, provide advisory, but have also developed a number of tools. This is taken from the so-called legislative guidance tool, which is a tool that allows states to strengthen the regulation of PMSCs. And this is giving an idea of how a national framework for PSCs, what are elements that a national framework for PSCs should contain. So starting with the general provisions, going over to the permitted and prohibited activities, what kind of authority is required, what kind of authorization, licensing, and registration is required, how do you go about the selection and contracting of PMSCs, the PMSCs and their personnel, and accountability and effective remedies. So this is really giving a logical framework to states wishing to update their regulation. And with that, I would like to thank you for your attention. The forum has a website, mdforum.ch, where you find a number of information on the document and the forum. Also, you could also, on the website of DCA's Business Security Division, you'll also find tools when it comes to PMSCs. And I look forward to all of your questions. Thank you very much.
Thank you very much, Jean-Michel, for your presentation and for providing this overview of the Montreux document and all the tools and services that it provides the states for the protection of victims of armed conflict. It is indeed a very relevant and timely document that can benefit a large number of states. And also, I would like to take this opportunity to thank you, DCAF and Montreux Document Forum, for all the efforts you've been putting in the promotion of the Montreux document. And now I will open the floor for questions. Most of the questions are not directed to a specific person, so if any of the speakers would like to respond, please feel free. I will be a bit slow with reading out the questions because I think the interpreters need us to slow down a bit, and I'd ask you also as speakers to slow down while responding to the questions, please. All right, the first question is in Arabic. هل للشركات الأمنية لوائح وقوانين
Are the PMCs having rules and regulations that they abide by that are not in contradiction with the IHL and other conventions? Dr. Muhammad Ghazi. Okay. Okay, so of course, so we have a number of initiatives. We have the International Code of Conduct for the private military and security companies. This is one of the initiatives common between the companies and the states. A number of texts asserted the importance of IHL and IHRL. So each company has to have a code of conduct. This is one of the obligations. Also, that there should be a contract between the company itself and the other party. This is a very important document for the respect of IHL and IHRL. This is in brief. Thank you, Dr. Muhammad. The second question, what is the impact of the presence of the PMSCs in the classification of armed conflicts, especially for the proxy companies fighting for states and fighting for the or fighting for groups? Does this change the classification of conflicts? Okay. Okay, yes, doctor, go ahead. So hiring of the PMSCs and its impact on the classification of armed conflicts, we have two assumptions. First, the PMSCs to be hired by the states. If it is hired by a state, saying that I'm not talking about a company now, I'm talking about an armed group from the legal perspective, from the IHL perspective, that we need this company to be controlled by a party to the conflict, a country party or a state party to the conflict, and it's part of its armed conflict, of its armed forces. So if the participation of this company, of the PMSC, now it is used by another company to take another state to take part in the conflict, so it is an international armed conflict. And similarly, if the armed conflict with a company, a state, a non-state actor, a non-state armed group, now we have a non-international armed conflict. So the PMSC is to be used by an armed group. So I didn't have the chance to talk about this point in my presentation. However, this is either used by an armed group or it is itself an armed group. So in any case, so if we classify it as an armed group, part of another armed group, or an armed group itself, so this is an non-international armed group, or it is hired by a state, then it is an international armed conflict. Thanks, Dr. Muhammad. The next question in English.
Plans or needs to update the Montreux document?
I don't know if you want to say something, Kalisiana, or I should go. Look, I think for the time being, we're not aware of any plans to update it. I think, and I would also see it more, the Montreux document is based on existing obligations. It creates a framework, and I think the real challenge is more on implementing what's already there than creating something new. I think the document is actually, the document and the international law body that sustains it is let's say up to date. It's more about making sure that then the regulation is implemented. And I think that's the focus, like making sure that then states that support it implement it adequately and regulation is strengthened.
Yeah, and maybe I'll just highlight once again what Jean-Michel said previously, that the legislative guidance tool, for example, is really useful in terms of providing that sort of up-to-date indication as to how to implement the Montreux document more effectively. And no doubt we'll continue to provide these sort of tools, but yes, definitely there's no plans to update the Montreux documents because it's pretty comprehensive.
Thank you.
And maybe I can just add, I can add a little bit, I think, just to give maybe, 2 minutes, giving a bit of experience from the advisory. I think, what we find is then when we start advising and looking at the situation in a particular context, the national laws might not be up to date, the national bylaws might not be up to date, national procurement policies are not up to date. We have insufficient resources in, sometimes there's not even a specific, let's say, entity that has been tasked with regulating. But even if there is, then there might not be enough staff or enough financial resources to do the job. So this is, I think, really the challenge we're facing, more than the fact. The international norms and good practices are there, but it's really then creating the regulatory frameworks for this to happen within a given country, but then also obviously from I think the extraterritoriality aspect then is another one, but to really create these structures.
Thank you very much. The next question is in Arabic. هل إنكار دولة ما
is the denial of any country that they do not have a PMSCs or particularly PMSCs not affiliated to this company, it can drop the responsibilities on any violations related to this company?
I would say maybe just from a Montreux document perspective, I think the document makes clear. This talks about the obligations of state to regulate adequately PMSCs. So clearly, the states have an obligation, and the fact that you can't simply discharge your obligations by saying we will outsource to a company this is precisely what regulation is about. I mean, you have responsibility, regulatory, and then also if you were, if the company is based in your country, you have a responsibility. But if you hire the company from as a contracting state, you also have a responsibility to make sure that that the way that the services you ask for the company are in line with international law. That there's the international law is respected. So I would say this is really saying there is no legal vacuum. You have a responsibility, and just to add on a side note, the document doesn't specifically mention, but what we do in the work is I think it touches upon, but it's also the issue of subcontractors. So sometimes there's a company will subcontract to other companies, and there might be a perception that then you can the companies, the main company is also not responsible. No, there's a clear chain there. So if a state contracts a company or has a company based in a state, and even if then the company subcontracts something else, to another company, there is still a clear responsibility under international law, and you can actually not get rid of it. It's there. There's no vacuum.
Actually, I'll follow up on a question that I read that was in English, so it will be in the English language as well, in terms of subcontracting as well, but not necessarily subcontracting, but it's in the case of recruitment of fighters by PMCSs in NIACs. Would they be considered PMCS personnel or not? And who would be accountable for the violations committed by these fighters that are recruited but are not officially PMCSs personnel? I'm sorry for reading the question very quickly for the interpreters.
Again, I think the Montreux document takes a very broad view on what constitutes a PMSC, and so I think the situation you describe would fall within that. If they recruited to provide some services by states, I think you would have the situation very likely, and then there would be a responsibility by both by the party that contracts, but also by the states where they hail from or the states where they operate. The contracting party, if the contracting party is a state, if it's a non, then something else. But the framework. I mean, the Montreux really takes a very broad definition of PMSCs, and then the obligations then continue to fall on the parties that contracts the PMSCs.
And I would just add that if we're talking about recruitment of people who are under the age of 18, for example, then obviously there are specific obligations under IHL and human rights law to not recruit children who are under the age of 18. And this would apply equally to private military and security companies, but specifically also to the states that might contract them. They would have an obligation to ensure that they're not recruiting children. And if they are, then they should be prosecuted for doing so.
Thank you very much. The next question is in Arabic. هل ترون أن تعديل?
Do you think that the amendment of Article 47 of the first additional protocol relating to the mercenaries, the application of the term mercenaries, will contribute in the broader application of IHL on PMSCs so that they are no more civilians and they are now combatants so that they have to apply by IHL? Dr. Muhammad? Okay, as I mentioned in my presentation that we have a number of issues related to Article 47 relating to the difficulty of its application and the application of the term mercenaries. Here it comes to the application of IHL. So in any cases, whether the amendment to IHL, the amendment to this article, so in any cases, the PMSCs either hired by a state or by an army group, they have to respect the IHL in armed conflicts. Also, Article 47 relating to the application in non-international armed conflicts. That's why we have the UN Convention of 1989. They have tried to cover the application of the term of mercenaries in non-international armed conflict. However, the convention wasn't adequately supported or sufficiently supported by states. I think in 2000, from 2001 and then up till now, we have only like 36 companies, 36 states supporting this. So the amendment to the convention in order to ensure the application of IHL is a little bit problematic. So IHL is a binding and obligatory in all circumstances. So the amendment to Article 47, in order to cover the operation of the PMSCs, now it's not mainly talking about the PMSCs, but it's about regulating these companies in a way that is in compliance with the IHL, specifically when it comes to the mercenaries. أريد أن أضيف بعض النقاط. فيما يتعلق بالمرتزقة.
From our perspective, I think it's really about strengthening regulation. I think we can have a definition. I mean, because the reason I'm saying this is, we've had the UN Convention as well on mercenaries, and which, is actually to really classify as a mercenary under the UN Convention. It's actually quite complex. I mean, it's a pretty narrow focus. So I think, it's the big focus from our perspective should really be about strengthening regulation, because this is, we really need to go for the whole of the the operations, and we already have, we can have the discussion. I think it makes sense to strengthen specific aspects, but the key challenge is really strengthening regulation with the existing tools.
Can I just add something as well? I completely agree with the other panelists in their responses, but also to note that, of course, Article 47 is within the Additional Protocol 1, and so there's obviously no plans to reopen Additional Protocol 1. I think that the legal protections in general under IHL in Additional Protocol 1 are very strong and have a strong basis in customary international law as well. I would also note, though, that if the participants are interested, then there is, of course, the UN Working Group on Mercenaries under the auspices of the UN Human Rights Council, which is doing a lot of work around private military and security companies specifically, and looking at various different aspects of it. So that might be interesting for them to look at that.
Thank you very much. There is a question in Arabic. ما هو موقف القانون الدولي الإنساني؟
What is the perspective of IHL relating to some civilian services of the PMSCs, like the polls, like the statistics for intelligence and security purposes that would serve one party to the conflict?
I mean, just, I can just from a, say, definition point of view, I mean, the document covers the whole spectrum of PMSCs. So that, applies, let's say, to PSCs involved in combat operations, but it also involves to PMSCs providing support functions. So logistical functions, and then I'm just quoting a bit, let's say, from concrete fields where we see PSC active. I mean, this is, logistical support functions. It can go all the way to managing weapons. It can be providing intelligence support, intelligence analysis. So there's a whole spectrum out there of services provided, and they would all fall within the document.
Thank you very much, Jean-Michel, and I think this actually answers another question that we had. And the last question that we will take, it will be in English as well. Is it accurate to say that state responsibility will often depend on the effective control or the complete dependence of PMCS vis-a-vis the state?
Sorry, could you maybe repeat it? I think at some point I lost one or two words. Sorry.
Hold on, sorry. Sorry, could you say that again, Jean-Michel?
Sorry, I didn't fully understand this question, but I'm looking at it now in the chat function. So yeah. And look, I can also give from my side, an answer on this. I think, effective control, yes. I think, control understood as effective regulation. I think, to have sorry.
I think we're getting a little bit of echo maybe from the Arabic translation side.
I'm really sorry for this technical problem, so I'll just repeat the question. Is it accurate to say that state responsibility will often depend on the effective control or the complete dependence of PMCSs vis-a-vis the state?
Look, I think on that, from my side, I think we should differentiate, because I think the responsibility of the state is there in any case. Whether it's regulating or not, but then the state fulfills its responsibility by providing for adequate regulation, and that regulation will be done for companies that operate on its territory, operate from its territory, or in the case that it contracts companies, and also in terms of contract management. So but I think we need to be careful in saying that if the state has complete control over the company, then it's responsible. No, it's responsible in any case for what the PMSC is doing, and it fulfills its responsibility by making sure that there's an adequate regulation in place.
Can I add something here? بشكل عام
So, generally speaking, about the control, there should be a clear relationship between the country and the PMSC. So here we have a state. It is clear that we have a state, and the state is hiring PMSCs. And according to the state responsibility, the state can even hire persons, or can give some of the responsibilities to, or have some of the tasks to these companies. So the state is anyway responsible. The effective control is not just the only decisive condition for that. Under any circumstances, for clear hiring, for the administration, providing any services, this is a clear relationship. So we should not only depend on the overall or the effective control. The state is responsible anyway. أريد أن أضيف نقطة هنا.
Agree once again with the other panelists, just to highlight once again the fact that state responsibility is entailed already. As I said in my presentation, under Common Article 1 of the Geneva Conventions, they have responsibility to ensure respect for IHL. So they have an overall responsibility to ensure respect, and it doesn't really matter as to how much effective control they have over the PMSC. But then, of course, the effective control test is more about what is the relationship between the state and the PMSC for the purposes of classification of the conflict, and for the purposes of the PMSC potentially being a party to the conflict. And I think that we all sort of clarified some of those aspects during our presentations.
Thank you very much. للأسف كان هذا آخر سؤال معنا اليوم. لن نستطيع
So unfortunately, this is the last question that we have. We cannot answer all the questions due to the lack of time. If you want to know more about this topic, you can download the attached files here in the Files tab, and on also the events page on the ICSC website and the Montreux Document Forum. We have also the publications and the book of Dr. Muhammad Ghazi. Finally, I'd like to thank you all honorable participants for your listening and active participation, and I hope you have enjoyed this panel discussion. Thanks so much. All thanks and appreciation to our experts, Dr. Muhammad Ghazi, Ms. Kelsiana Thain, Mr. Jean-Michel Rousseau. Thank you so much for your presentation and for your incessant efforts on the PMCs on the ground. Of course, I'd like to thank our interpreters for their efforts, and sorry for speaking too fast. Thanks for Mrs. Sally Talal, and thanks for Professor Dr. Suhair Mahfouz. So, in the end, I'd like to thank all those who participated in organizing the seminar from the Montreux Document Forum team, and especially Samuel Kong, and also from the ICRC, the regional team, Dr. Omar Mekki, Advisor Ali Al-Bedrawi, Advisor Inja Abu Al-Ayun, Miss Sally Talal, and Miss Omnia Abu Al-Ila. Thank you so much, and wish to see you soon in another event. Thank you, everyone.